Yeah, dear guests, I think we are quite ready to start, if you don't mind. I'm just so happy to welcome all of you here in Dubai and online for our morning discussion on cooperation between state courts and arbitration. And I really hope that in the end we will be able to answer the question, are they really part of a whole? Are they really collaborate together? My name is Valeria Butyrina, and I'm the Deputy CEO of the Russian Arbitration Center. And I just would like to start first why this topic is so important to the Russian Arbitration Center. As you might know, with the opening of our first office at the Dubai International Financial Center last year, we expect receiving more and more DIFC-seated and UAE-seated arbitration. And in our capacity at the arbitral institution, it's just essential, it is mandatory for us to know the law of the seat so that our awards would be valid and enforceable and our arbitration would be effective. At the same time, we acknowledge that sometimes knowing how the law is applied is as crucial as knowing the law itself. Therefore, it is really vital for us to get the insights from the courts on their views, their attitude to arbitration, and from the legal practitioners in the jurisdiction. I just would like to give you a little bit of a background on the Russian Arbitration Center and our approaches to administering disputes. Well, I should tell that we are really keen on our arbitrations. We really care a lot of our arbitrations. And if you would wake up any of our employees at night and asks, like, what's going on in case I-56-21-23, he will be just so happy to provide you with the old case history, but then he will be fired, of course, because it's confidential. Still, we really want our awards to live happy ever after their rendition. And therefore, in ROC, we adopted quite an unusual practice. In our arbitrations, the employees of the ROC act as tribunal secretaries. So these people are assigned from the institution to the tribunal, and they help them throughout the whole proceedings. So they supervise the proceedings, they ensures that the proceeding complies with the law of the seat, it complies with the arbitration rules, it complies with parties agreement, and sometimes it complies with the law where award will be enforced. So we understand that it's not a common practice, but we think that it allows us to prevent some procedural irregularities early on, first one, and second, that it allows us to be fully involved in our arbitrations. We also do soft scrutiny of the awards. What we do is we are checking the awards on some procedural irregularities, some technical mistakes, and sometimes we can suggest the tribunals to reinforce a certain argument so it would be more clearer to the parties and eventually to the courts. Why we do it? Because we would like the courts, when they see our awards, when they see our arbitrations, to be sure that it is fully compliant with all the necessary regulations and all the necessary rules. I would like to say that we do not see us as competitors to the court. We totally understand that arbitration lacks coercive functions, and we would like to see this collaboration more as something immense and something beneficial. And we try to facilitate this process as much as we can, as smoothly as we can. In this regard, we have some provisions in our arbitration rules that provide us to make this collaboration quite easy. For instance, we have provisions on the storage of the arbitral awards, and it says that we need to store the awards within 10 years, and we are taking the responsibility to provide all the materials to the court within the time frame specified in the rules. sometimes it could be 1 or 2 days, depending on the situation. And in this regard, we try to collaborate with the courts. We try to contact them and try to find suitable solutions. For instance, we sometimes bring electronic copies of the case files, or we bring all these bundles by ourselves to the courts. Moreover, we of course have provisions on taking of evidence and on assistance of the state courts to arbitration. And in this regard, we help all our arbitrators with filing this request to the courts and then facilitate this cooperation between arbitrator, state court, and institution. In our view, such proactive approach and such willingness to cooperate helps us to build this strong bond between the institution and the court. And we think that this bond is really essential because it increases our credibility in the eyes of the court. And we really hope that we could do it not only in Russia, but abroad. Still, there is a question that we cannot answer. It is, should arbitral institutions be involved in the process more? But not like bodies, but like experts or observers. For instance, can we submit some position in the cases on enforcement and recognition of arbitral awards or annulment of arbitral awards, especially if this issue concerns some procedural irregularities, considering the fact that we know the law of the seat? Can we submit amicus curiae briefs? And if we can we do it on our own initiative or under the request of the court? And we were wondering whether such active engagement could be misconstrued as favoring one of the parties, or it should be seen like really fruitful cooperation, some way to reciprocate to the courts for the assistance functions. I'm really hoping that today we will be able to answer some of these questions. And I would like to give a floor to Mr. Faris Nasrallah, Senior Arbitration Counsel at the Crescent Petroleum. I must say that Faris, it was totally Faris's idea. It was his intention to host this event. And I'm really sure that he will be glad to tell us more about the rationale behind this. Thank you, Faris.
Good morning, everyone. First of all, I'm pleased to see so many friends and colleagues here. Thank you all for joining us. I'd like to thank, firstly, the Russian Arbitration Center and all of their staff members, Valeria, Katerina, Yulia, and the others in helping bring this event to fruition. And also for their kind interest in the topic of judicial assistance in arbitration in the UAE. Secondly, I'm grateful to the DIFC Academy for lending us these brilliant facilities that I'm glad to be making use of today. The aim of today's event is to explore the nature and availability of judicial assistance in UAE-seated arbitrations, and more broadly, our perceptions and practices regarding the relationship between the courts and arbitration in the UAE. Whether by choice or otherwise, judges are often shielded from the arbitral process in the UAE. Now, in 2009, in an edition of a locally published arbitration journal, the editor of which, the founder and the editor of which, I'm happy to say is with us today, and that was a surprise to me, but Dr. Hussam Al-Talhouni, thank you for joining us. That journal contained a very revealing and unique section on interviews with arbitrators. Interviews with, well, they did include arbitrators, but particularly interviews with local court judges in the UAE. And one of those exchanges in a 2009 edition of that journal was with Judge Obaid Al-Ka'bi, a court of first instance judge in Fujairah. Now, 15 years after its publication, a particular sentiment and turn of phrase expressed by Judge Al-Ka'bi lives on and continues to pose important questions about how we perceive and practice arbitration in the UAE. He noted, and I quote, the following: "It's necessary to enhance cooperation between members of the judiciary and arbitration centres so that such centres can achieve their goals and no longer be regarded as competitors, but as a complementary tool, because the judiciary and arbitration are two sides of the same coin." Now, the Al-Ka'bi view of arbitration, if he will permit me to call it that, or perhaps we'll call it the two sides of the same coin view of arbitration, poses fundamental conceptual questions about the place of arbitration within national legal systems or as an international legal order in its own right. And while those questions are vital to determine our understanding of what arbitration is and how we practice it, I think they're, very theoretical questions that are perhaps best left for another day. What is crucial for us that emanates from that quote is the impact that our perceptions have on our willingness to seek judicial assistance in arbitration, and particularly our decisions on how we confront, control, and handle judicial power and judicial procedures as they might impact the arbitral process. So the purpose of today's event is to test, and if necessary, to challenge the following adverse binary perceptions about judicial assistance in international arbitration. The first of those perceptions is that courts act against arbitration and that they're in some kind of perpetual duality. So visually, it's courts versus arbitration. And that they live not only in constant challenge, but one seeks to usurp the other. The language of usurp and usurpation is historic when it comes to discussing the place of arbitration, but that's essentially the first perception, that courts and arbitration are in context. The second perception is that courts are a place for enforcement only. So they have a limited role. They exist to serve in the way that we would understand most commonly the application of the New York Convention or other conventions to do justice on an award. And the final perception is that courts are a last resort when things go wrong. So that's to say, if parties, counsel or otherwise do conceive courts as having a role in arbitration, they're incredibly wary of court involvement, and it's seen as something that you only enter into when something has failed in the arbitral process. God forbid an arbitrator has passed away or needs to be challenged or changed or recused for some reason, and so on. The prevalence and entrenchment of those perceptions, particularly in the UAE, mean that the potential benefits for arbitral users in exploring the full extent of court procedures to assist arbitration are neglected, and therefore disputants of all stripes invariably become less connected to their curial courts. So in my personal experience, I've rarely come across practitioners in the UAE who identify, let alone consider actually proceeding with applications for interim judicial assistance, which is not necessarily the position in other seats. Now, of course, pre-award applications to courts can prove disruptive and expensive, but to simply dismiss those procedures as to be avoided at all costs may in certain circumstances be a missed opportunity. And I say that for parties, counsel, and also for tribunals. We know in the UAE that there are established procedures for obtaining interim judicial assistance under both the UAE federal law, that's Article 21, and Article 21.4 to be precise, and also the Russian Arbitration Center rules under Rule 36. Now, the question at hand today, and with that background, is ultimately seeking to answer whether or not parties pursue interim measures and judicial assistance. And that will depend on the nature, complexity, and the value of the dispute. But it's also about the arbitral landscape and the arbitral ecosystem in which the arbitration exists. It's about the capacity of the courts to work in tandem with arbitration and for arbitral users to feel confidence in those courts to assist the arbitral process. To explore these, what I hope are very pertinent issues, I'm honoured to be joined by an illustrious cohort of panelists comprising senior judicial figures in the UAE and UAE private practice lawyers. The first of those is His Honour Justice Shamlan Sawalehi. Justice Shamlan has over 25 years of experience in cross-border litigation and arbitration across common law, civil law, and Sharia systems. He was educated at the UAE University, the Dubai Judicial Institute, and the University of Westminster in the UK. Justice Shamlan joined the DIFC courts as a judicial officer in 2010, becoming a first instance judge in 2013, a Court of Appeal judge in 2017, and in 2020 was appointed as the judge in charge of the arbitration division of the DIFC courts, where he's also the chair of the court's arbitration group. He previously founded the Shamlan law firm and has extensive experience in private practice. He also served as a senior public prosecutor at the criminal and civil divisions in Dubai and was involved in investigations of various high-profile commercial and financial crimes. Justice Shamlan has served as a sole arbitrator, a co-arbitrator, and the chairman of many arbitral tribunals in the MENA region and Europe. He's been selected as a chair and a member of various arbitral institutions, including in the UAE, Saudi Arabia, Russia, Malaysia, and India. And in April 2023, was nominated by the UAE government as their representative at ICSID. Beside Justice Shamlan, we have His Honour Justice Mr. Hassan Al-Shadhli. He's currently a judge at the Dubai Court of Appeal. Justice Hassan was educated at the Beirut Arab University of Alexandria. He qualified as a lawyer in Sudan in 1988. In 1989, he was appointed as a judge in the public courts of Sudan. That's a single court chamber hearing criminal, civil, personal status claims. He was awarded the higher judicial status in the Sudanese courts in 1998, following which he assumed a judicial position in Dubai with the Court of First Instance in 2005. In 2012, he was promoted to serve in the Dubai Court of Appeal, and in 2023, promoted to the Dubai Court of Cassation. Justice Al-Shadhli is currently head of the Commercial and Arbitration Division of the Dubai Courts. He's also participated in capacity building projects for judicial learning on arbitration in Rwanda and Egypt, and serves as an arbitrator in proceedings in Sudan. The final of our very honourable judicial members is His Honour Justice Ahmed Abu Zaid, the judge in the Ras Al Khaimah Court of Cassation. Judge Abu Zaid currently serves in the Ras Al Khaimah Court of Cassation and is a member of the UAE Unification Authority for Federal and Local Judicial Principles. He was previously, and I was very interested to learn this, he was previously the Vice President of the Court of Cassation and the Supreme Court of Egypt, as well as being the head of the International Relations Department at the Egyptian courts. He's been a principal draftsman in a number of articles of UAE legislation, including the 2021 law on establishment of mediation centres. Judge Abu Zaid has extensive experience in ADR, criminal justice and commercial disputes, and also serves as an independent arbitrator and a mediator. To his left, we have Miss Julia Zagonek. She's a partner at White & Case in Dubai. Julia is an English solicitor advocate and a partner in the international arbitration practice of White & Case. She was her head of disputes at White & Case in Moscow, dividing her time between London and Moscow for over a decade. Julia is now based in Dubai, where she focuses on Middle East commercial and investment treaty arbitration while continuing to lead the Eastern European and CIS disputes team. Julia specializes in complex multi-jurisdictional commercial disputes and has significant experience and expertise in international commercial and investor state arbitration. She's a member of the ICC Court and the VIAC International Advisory Board and is regularly appointed as an arbitrator. Finally, and by no means least, to my left is Mr. Mohammed Gaber Abd Sabur. He is a senior associate with Al Tamimi in their Sharjah office. He is dual qualified in Egypt and the UK with over 15 years of experience in the profession. He's graduated from the Faculty of Law at the Alexandria University in Egypt. Mohammed's a senior counsel at Al Tamimi, as I mentioned, in their Sharjah office, and handles a wide range of civil, commercial, and corporate disputes in the UAE. He also, from my own personal experience, has direct knowledge with seeking judicial assistance in the local courts. Before joining Al Tamimi, Mohammed was a legal manager of a publicly listed company in Qatar, where he managed a large legal department and was recognized by Legal 500 on their GC power list. So with the introductions done and that very, very brief précis from me, I'll take a seat among this illustrious panel and put some questions to them if they'll accept them. So, firstly, the first question for Justice Shamlan. Do you have a microphone? Yeah. Good morning. So I've got two questions for you emanating from that introduction. The first is, having heard that assessment of mine, would you agree that these are the perceptions and challenges that face the courts with regard to the arbitral process? That's the first question. And the second, if I can put it to you now, is, if possible, can you please explain, so that it's clear for us as practitioners or stakeholders of other stripes, the availability of DIFC court procedures to support arbitration, not just in enforcement, but throughout the lifespan of the proceeding.
Thank you. Appreciate it, Faris. And welcome. Assalamu alaikum for everyone. Thank you for Russian Arbitration Center, which I'm part of anyway. And thank you for the audience and my panelists. Let's go with the easiest part, the DIFC court, if I may. The way how we are thinking to market DIFC as a global seat for arbitration is to make the DIFC court as a supervisory court very more friendly to arbitration. Now, as you just explained, it's not just about enforcement and recognition award afterwards. It's about what this court, or what the DIFC court can do for the parties before that, long time ago. We start from the main principle of party autonomy. So when the party already choose that pathway to solve their problem through the arbitration, and we are thinking that we have to respect that choice. So what we can do to respect that choice, there is a lot of solutions we can assist the party with early days before the award is rendered and the award is issued. One of them, I don't want to take too much time on this, maybe we come back to it. One of them is to provide an interim relief for party, which is sometimes is not exist in our neighbor court or maybe in another court within the UAE. Those remedies, most of them, they came from the common law practice, namely the anti-suit injunction, which is I am very famous on now in the IFC court. We're respecting party choice, and we are asking the parties not to pursue any arbitration or to take any more action before the local court if they already have arbitration clause, and they have to come to the seat of the arbitration to argue whether the arbitration is valid or not valid. So we issue those anti-suit injunction to the parties. Now, I am very criticized to do this with my colleagues in Dubai court or another court, because they say, why you prevent us from hearing the party? I say, look, I'm not preventing you as a court. I cannot do that. I'm preventing the party. And this is the support we can give to party to uphold their agreement. Another thing, not just an anti-suit injunction, but attachment and interim relief. There is a time when we have a DIFC, LCIA in the DIFC, and even still now, the party, even before they starting arbitration proceedings, they jump to the DIFC court and ask for emergency, if you like, a relief. And we are acting as emergency arbitrator. Within 24 hours, we give them the freezing order. If they approaching the center, they will maybe take more than 3-4 days to get that remedy. So very basically, and I can discuss this further later on, this is what we're trying to do, is to helping the party even earlier before the arbitration is finished and during the arbitration. We haven't practiced yet in terms of a judicial assistant for taking evidence, if you like, or we haven't have any experience with that. Most of our experience with the freezing order, even before the arbitration started, anti-suit injunction, of course, later on, another practice which is familiar with from the common law, the worldwide freezing order. This is not practiced before the local court here. They jump to the DIFC court. Recently, I have an application involved, an arbitration was issued in India, and both party has nothing to do with the DIFC court, but the DIFC court law allow the party to come and file a recognition enforcement application before me, and I have to give the party the opportunity to enforce the order, even if you don't have an assets in the DIFC. So this is that extreme approach, if you like. I hope I answer that part of your questions. Now get back to the first part, if you can just remind me what was it.
The first part is really what I think brings the DIFC courts closer to the Dubai courts. Sorry,
Sure. No, I understand. No, I can hear that.
I think this is better, yeah.
Sure.
So the first question is really what brings the DIFC courts back to a direct relationship to the Dubai courts, in the sense that they operate in the same jurisdiction and in terms of national jurisdiction, and are therefore impacted by perceptions and practices about the court systems as a whole. Yeah. And so the question is then, do you find that the adverse perceptions about judicial assistance generally in the UAE impact or limit parties from bringing those actions before the DIFC courts?
Well, I think moving, I don't want to speak about the past and the perception was before, but I think after having issuing Decree 34, if I remember very correctly, about DIAC, and things get in order now, especially the connection between DIFC court and Dubai court. It is more clear now. If it is, for instance, a DIAC case, then it goes to the Dubai court, and the UAE law will apply. If it is a non-DIAC case and the seat is DIFC, or the default seat will be DIFC if there is no choice on the seat. So I think it might be before, where the reception is, there is a lot of confusion, if you like, between the practice between both courts when it has come to arbitration. But going forward, I think the scene now, or the structure now is more in order, more clear. But I'm happy to discuss those ideas later on and comment on my colleague as well. Appreciate it.
So the next question will then pass to Justice Hassan. I think for those in the audience who want to follow in English, you'll have to put the headset on for the response. But Justice Hassan, my question to you is, having heard what you've heard from Judge Shamlan, and also given your wealth of experience in the Dubai courts over the past 2 decades, my question is, do you often see applications for interim judicial assistance for arbitrations while they're ongoing? What is your experience with those applications? And if you've seen them, how do you handle them? And more generally, how do you see the role of the courts in assisting arbitrations?
بسم الله الرحمن الرحيم. ابتداء قبل أجيب على السؤال، أنا برجع لتعليق الأخت ممثلة المركز التحكيم الروسي في سؤال عن التنافس بين القضاء وبين المحكمين. وأنا ما بقول في تنافس ولا في تحدي ولا إبراز عضلات، بالعكس بقوة القانون أنا ملزم باحترام التحكيم، باحترام ما يرد من التحكيم من قرارات ومن أحكام، وملزم بتنفيذها. وبقوة القانون الحكم الصادر من هيئة التحكيم يعتبر حكم ملزم للمحاكم ومنهي للخصومة، ويحوز قوة الأمر المقضي أمام المحاكم بحيث أنه لا تستطيع أن تنظر النزاع الذي صدر فيه حكم التحكيم مرة أخرى كما تعلمون بقاعدة الأمر المقضي. بل بالعكس أنا برى إنه المحاكم بتقدم مساعدة أو مفروض عليها تقديم المساعدة بقوة القانون وقبل ابتداء التحكيم ذات نفسه. يعني ممكن يأتي الأطراف بطلب إجراءات، اتخاذ إجراءات تحفظية بنزاع تم الاتفاق عليه بنظر بالتحكيم، ويكون ذلك قبل انعقاد جلسات التحكيم أو قبل أن تباشر هيئة التحكيم نظر التحكيم، فضلا عن يعني الدور الكبير في مسألة التحكيم الحر، في مسألة تعيين المحكم بتقوم به المحكمة أو يلجأ الأطراف للمحكمة في إعادة في تشكيل هيئة التحكيم، في تعيين المحكمين، في كل ما يعترض تشكيل الهيئة أمام تشكيل الهيئة ويكون فيها القرار للمحكمة. ده جانب إيجابي من المحكمة. فضلا يعني أنا بنظر قضايا تحكيم في محاكم دبي منذ العام 2017. يعني هنالك تزايد في دعاوى التحكيم أمام المحكمة بصورة مضطردة. ومن ضمن الملاحظات يعني بطلان أحكام التحكيم تكاد تكون يعني إذا لاحظ كل الأساتذة الموجودين في دبي، يعني دعاوى البطلان الحكم ببطلان حكم التحكيم يكاد منعدما تماما. وهذا كله بالصغة في التحكيم، ويرجع مرة أخرى لأنه حتى الرغابة القضائية محكمة التمييز بتصر على أنه الرغابة القضائية تبقى رغابة شكلية في مسألة الإجراءات وليست مسألة تقدير الدليل المختصة به هيئة التحكيم، باعتبار أنه هيئة التحكيم يعتبر قضاة منفصلين ويؤدوا عملهم بالصورة حسب إرادة الأطراف وحسب ما يلزمهم القانون. وبالعكس هنالك أحكام في محكمة التمييز يعني من المبادئ الموجود فيها الإغلال في أسباب البطلان، الإغلال بأسباب البطلان والتغيد بأنه أسباب البطلان واردة على سبيل الحصر ولا يجوز القياس عليها. يعني ما ممكن اعتبار هنالك سبب آخر ممكن أن يدفع به المدعي اللي هو المحتكم والمحتكم ضده في دعوى التحكيم ويكون سبب للبطلان تغيظ عليه المحكمة من حالات البطلان الموجودة في المادة 53. وكما قلت يعني تكاد قضايا أو دعاوى البطلان على بطلان التحكيم شبه، يعني أنا بقول قاعدين ناخذ بكلام، يعني ناخذ بكلام المحكم كثير جدا ما عدا في مسألة الإعلانات في إجراءات التحكيم أو إجراءات إعلان الطرف المدعي بالتحكيم. أما النواحي الموضوعية فهنالك إجماع تام بأن المحكمة تتمسك في الدخول في الموضوع وفي تقدير الدليل، وأنا بفتكر دي مساحة كبيرة جدا وبقناعة للتحكيم ودوره في حل المنازعات، بل أنه المشرع اعتبره وسيلة من وسائل حل النزاعات بجانب القضاء والمسائل الأخرى، التوفيق مثلا. فأصبح بقوة القانون التحكيم يأخذ دوره. وهنالك يعني في سنة 23 يعني دعاوى البطلان فاغت في محاكم دبي 95 دعوة. دعاوى التصديق على الأحكام أكثر من 142 دعوة. دعاوى تعيين المحكم أكثر من 208 لتعيين محكم. وأنا ده براه مراعاة بالعودة للسنين السابقة، برى أنه هنالك في طفرة في التحكيم في أمارة دبي، وفي لجوء الأطراف للتحكيم. معنى ذلك أن هنالك قبول عندما يكون هنالك طلب بتعيين 208 محكم من المحكمة، وغالبا يكون في دعاوى التحكيم الحر، وتأتي إلى المحاكم من التحكيم الحر والتحكيم المؤسسي ما يعد في حدود 50 أو 60 دعوة. أنا أفتكر أن هنالك قناعة من المجتمع ذات نفسه بالتحكيم. وبالنسبة للمساعدة هيئة المحكمة للتحكيم، هو مفروض بقوة القانون. بقوة القانون أنا كقاضي ملزم بأنه أقدم المساعدة لهيئة التحكيم، وبطلب منها أو سواء بطلب من الأطراف. وحتى مرحلة إصدار الحكم الإضافي في دعوة في تفسير الحكم، أو تصحيح حكم التحكيم إذا عجزت الهيئة أو حال سبب دون أن تقوم بذلك الإجراء، فيكون المحكمة هي المختصة بالحكم الإضافي، مع أنه هو حكم تحكيم، لكن المحكمة المشرع أعطاها الحق في إصدار حكم إضافي أصلا المختصة به هي هيئة التحكيم. وأنا بذلك بعتبرها يعني مساعدة كافية جدا في إنه نحن نتبع التحكيم ونتبع هيئة التحكيم ونؤمن بما تصدر من قرارات، فضلا كما ذكر الزميل أستاذنا الشملان في اتخاذ الإجراءات التحفظية والإجراءات الوقتية بطلب من الهيئة أو بطلب من الأطراف، فضلا عن المساعدة في جلب البينة وإلزام الشهود بالمسؤول أمام الهيئة لتقديم الإفادات أو الشهادة الشفهية، أو لإبراز مستندات بواسطة طرف ثالث لم يكن طرفا في إجراءات التحكيم. وهذه كلها تعد من مسائل المساعدة، فضلا عن الإنابة القضائية في الإعلانات، واللي هي طلبات تتزايد بكثرة أمام محاكم دبي المختصة أصلا بنظر النزاعات الموجودة في أمام هيئة التحكيم. فأنا أطمن الحضور، ليست هناك تنافس، وليس هناك تعدي، كل يؤدي دوره. ونحن نثق تماما في هيئات التحكيم. وأنا كقاضي أطلع على حكم التحكيم، أي ممكن أكون أنا ملزم بالنظر في الإجراءات ما اتبعته هيئة التحكيم وتقدير الإجراءات دون الموضوع، لكن هنالك أنا بفتكر نصين اللي هو مدى تطابق القانون الحكم التحكيم مع القانون الواجب التطبيق. وكما أقول للزملاء في قضاة محكمة التمييز أن هنالك رغبة موضوعية في مسألة النظام العام. لازم الحكم الصادر من هيئة التحكيم يوافق النظام العام، أو أن تكون المسألة التي تم إحالتها لنظام التحكيم صالحة للفصل، باعتبار أن هنالك منازعات المشرع ما أجاز النظر فيها بواسطة هيئة التحكيم. وهنا تأتي الرغبة الموضوعية لحكم التحكيم. وحقيقة ما اطلعت عليه من كمية كبيرة من الأحكام، وأستاذي كمال الدكتور كمال ملص من المحكمين الموجودين، اطلعت على كمية وأستاذنا العيدروس يعني طلعت كمية على أحكام التحكيم، وحقيقة أنا برى حتى الأحكام اللي تأتي من محاكم أجنبية يقوم المحكمين بدورهم تماما في مسألة التطبيق القانون الواجب التطبيق والمتفق عليه بين الأطراف، بدليل أنا بفتكر إنه هنالك يعني بدليل إنه بطلان أحكام التحكيم تكاد منعدمة تماما من 2018 من 2017 أنا رئيس لهيئة لمحكمة التحكيم، وأتمنى أكون جبت على السؤال يعني.
احنا شاكرين لك أستاذ سعادة القاضي، شكرا كثير. I'm very grateful for the extent and the depth of that answer. It went far beyond the particular question of interest, but totally to the point. And as it serves our discussion, there are two elements of that very, very comprehensive answer that Justice Hassan has just given us that arise for the next question of consideration for Justice Ahmed. The 2 points that I picked up on from Justice Hassan were, first, that he's obliged to follow the law and that the procedures are already available in law. And second, that it's up to the parties to make the application to the court and then he can act. Having heard all of that, Justice Ahmed, what's your experience in the Iraq court, the Ras Al Khaimah court, when it comes to interim judicial assistance in arbitration? And also, given your background and your knowledge and experience with preservatory measures in the civil and commercial court process generally, to what extent do those practices inform you when you come to dealing with an application in the realm of arbitration?
Thank you, everybody. I'm very happy to be with this distinguished event, and thank you for this question, which is, I think, it's very important to answer about. I'll try to be precise and short for the 2 points that my colleague raised. My point of view, from my experience, that there is no competition between the judiciary and any arbitration panel, because it's very simple. The thing that any arbitration settlement, this is, in the first place, this is something that I was in charge of it. So my role is to help, not my role not to compete. I'm helping the parties, I'm helping the arbitrator to achieve the role or the mission that he is supposed to fulfill. So when we are dealing with such a kind of an assistant, yeah, I'm assisting the arbitrator, I'm assisting the parties, especially when the parties need to have what kind of a space to give some kind of evidence, or try to stand to prove his ground. He asked for some kind of process, some kind of time, of chance to give this kind of evidence. I'm agree with my colleague that our role at the court is to try to respect the will of the parties. But this is not our only role in this operation. We are trying to help them, give them the chance, and to be sure that the process being followed, and and each party get his fundamental guarantee. In this path, I should try to give him a chance when he asks for my help. He is usually asks for my help just to take the enforcement order or try to get this kind of a case, nullity of the order. I'm not really familiar with all the process of of each center of arbitration, but they are all have this kind of a common thing. They are trying to settle the case. Okay, so when I'm dealing with this kind of an order, I'll try to be sure that you get your fundamental rights as if you are in front of me in the court. This is my main concern. So any kind of an argument that you are trying to raise in front of the judiciary in order to get rid of the arbitral of the award, I'm not going to let you do this. You got to run with it. If I try to prove yourself and give me some time to give you some kind of a what do you call it, a help by getting evidence, or try to prove if you are trying to enforce the international order in Great Britain or something like that, you should prove to me that you are following the process the process that the law apply to enforce this order. All in all, this is the first point. The second point, to respect the parties' will does not mean that I should make this kind of a negative side or negative situation, or just try to ask you what you want. Okay, I will give you whatever you want. No. I should be sure that you have this kind of a right to give you this kind of chances. I think any this is what I have in mind.
That's very helpful, Justice Ahmed. Thank you very much. Over to Julia now. Firstly, I'd urge you to obviously make any comments on what you've heard, but of interest for me and perhaps some of the practitioners in the audience is to have some insight from you into your expectations or the expectations of arbitral users when it comes to judicial assistance. Is this something that you find yourself having to educate parties on? And is it a factor for you when advising clients on forum shopping? And of course, taking into consideration your hybrid cross-cultural experience between Russia and the UK and internationally, very keen to hear your views now that you're based in the UAE.
Thank you very much, Faris. And first of all, thank you very much to the Russian Arbitration Center and the DIFC Academy, and Faris, to very kind introduction. And of course, it's an honor to be part of such an esteemed panel. I have the easier task of all of my panelists, because I am not going to talk about how things are. I'm going to say how the users like it to be. And I don't know, sometimes perhaps I'll be way off what the courts are doing here. Sometimes I'll be way off what the courts are doing in what is considered to be the more sophisticated, sometimes unjustly, jurisdictions, such as England. I will be looking at how both the Russian users or users from the Russian Federation and those who have to interact with the Russian users, as well as the English users of arbitrations, what is it that they are expecting? Now, first of all, let us think about this jurisdiction in the context of its attractiveness. How is a jurisdiction measured, whether it is attractive or not for arbitration? Typically, it's how many people choose it as a seat. And I would like to remind everyone of the latest, I think it's the 13th survey by Queen Mary University of London. Unfortunately, it was in 2022 still, and focused mostly on arbitration in the energy sector. But we remember that that survey and empirical research is always very useful in this regard. That survey identified Dubai as one of the top 7 choices as a seat, along with London, Singapore, Paris, Stockholm, New York, and Geneva. And it is the best result that Dubai has achieved ever in these sort of surveys. And I firmly believe that it was, if another survey was conducted since 2022, because we are in a slightly different political and economic world, the results would have been even better for this jurisdiction. The previous rankings came out in 2021. Again, that was a very difficult world politically, economically, and Dubai was the 10th preferred seat, with Singapore and London sharing the first place. And I do believe that things have changed quite a lot since then. So it is very important in the context of East-West disputes that UAE and in general, and Dubai in particular, has every opportunity to replace those seats that are traditionally considered to be neutral, such as Stockholm, for example, or Switzerland or London. These jurisdictions are no longer perceived to be suitable because they are, certainly by the Russian users, considered to be unfriendly. Eastern users are looking for a suitable replacement. And they're looking at a very different and new criteria of neutrality. Then there are their Western counterparties who are being dragged, kicking and screaming, away from their preferred choice of seats, be it London, Paris, or Stockholm, so away from their comfort zones. And they're also looking for a minimum set of requirements from a seat, and are looking at Asia and looking at Middle East. And then there is a third category that people don't usually talk about. It's nothing to do with Russia. It's nothing to do with people who deal with Russia. But there is a category of users who are just a little bit fed up with the usual seats, and they're looking for a change for a whole variety of reasons, be it the costs, be it convenience of location, but we mustn't forget those as well. So though I'm sure most of you remember why Stockholm was always considered a choice, a preferred choice of neutral seat for Russian parties, because during the Cold War years, it was a very popular seat of arbitration chosen by state parties because it was considered to be not involved in the Cold War tensions between the US and Soviet Union, and it was not part of any military alliance. Now the world has changed, and it is no longer seen as a jurisdiction that provides the guarantees of neutrality and independence. And in addition, on a practical level, parties from Russia and neighboring countries are finding it difficult to travel into the EU, and thereby that's also going to be a factor that is relevant. And the same goes for Switzerland, a country that was traditionally considered to be upholding the principles of neutrality, is now adopting sanctions against Russia, and therefore will not be considered as a neutral and suitable place. So in this context, the UAE has every opportunity to become a neutral destination for resolving disputes involving Russian entities, but as I said, not just those. And disputes that would typically be heard in European jurisdictions are now already, we see, being redirected to this region. Now let's turn to expectations. So for sophisticated users, and nowadays I think we are dealing mostly with sophisticated users who know what the benefits of arbitration are. It's not a matter of whether they need to be convinced whether to go to court or to go to arbitration. They're looking at arbitration with a seat where they can have suitable judicial assistance that they're used to. Be it London, be it Paris, be it Stockholm, and maybe sometimes Russia, but that's a contentious topic. So what are they looking? The expectations are actually quite simple. First of all, the court, and that essentially means the judiciary, must be familiar with the issues of international arbitration process and also be fluent in resolving those issues. This often comes down to having, or the discussions always center around having a specialized court, for example, which is tasked with all arbitration matters. And the purpose of that centralized court is not just to create another layer, it's really to achieve consistency. So everybody's on the same page, consistency in decisions. A topic that was much debated in Russia in the course of 15 years without getting very far, unfortunately. Or the users look for specifically assigned judges or divisions within the court system that can deal with arbitration matters, or some other way of ensuring that judges are alert to the issues. Now, you've heard today from the esteemed judges their views on, for example, setting aside challenging of awards. And it's great to hear that awards are very rarely set aside, but there is another part of that coin. If you don't set aside awards, and it's great because that means that you assume that all tribunals that have rendered those awards are fluent, excellent, and have never committed a serious irregularity. But that also, the more time passes and the lack of practice starts to give the users a little thought. Perhaps the judges are, in their desire to be arbitration friendly, are actually ignoring some of the issues. They're doing everything they can to make that award stand. And again, that assumes that every single tribunal that you come across conducts itself in an appropriate manner so as to render an enforceable award when no procedural irregularity takes place. So turning back to the challenge of awards, those familiar with the way the English courts approach applications to challenge. So you've got the section 67, which is jurisdictional, and then you've got section 68, where the serious irregularity falls. So those who are used to that process may be interested to see how a UAE court would deal with the following issues. And most of the examples I'm going to give are from the English court practice. So start with the easy ones. How quickly must the party raise a jurisdictional challenge? Again, the English court will tell you very quickly, and it's not a matter of months, it's a matter of days. Whether a parent company of a party to arbitration can be joined to proceedings challenging the jurisdiction. And again, it might be desirable in the broader interest of justice context, or in order to fulfill the overriding objective. Again, I'm not talking about rules, I'm talking about exceptions, and these exceptions are important. They're the ones that safeguard the judicial support. Again, the successful challenges of jurisdiction in the English court are rare. But the question again is whether a UAE court would consider any summary dismissal of an application where it is considered that the chances of success are nil. There's no prospect of success. Now, turning to the certain allegations that would amount or would not amount to serious irregularity, again, there is one extreme where the court considers everything and in exercising its judicial function, compares the conduct of the tribunal to how a court would conduct itself. And that inevitably leads to being perceived an arbitration unfriendly jurisdiction, because that's not what the court should be doing. But let me give you an example. What would a UAE court do if it was faced with an application under the ground of serious irregularity, saying that the tribunal ignored or failed to have regard to evidence relied on by one party? Again, and the English court would say, well, not in most circumstances. Whether the tribunal's reasoning was crazy, illogical, irrational, or otherwise giving inadequate reasons. would that be a successful challenge? Again, the English court in most cases would say no. Whether the tribunal exercises discretion in making procedural decisions, for example, refusing to adjourn a hearing for reasons relating to a pandemic. Again, the general view of the English court is that it should be extremely slow to interfere with the discretion of the tribunal, and only if the tribunal reached a conclusion that when the court is looking at it, no reasonable arbitrator would have reached, having regard all the circumstances, and also having regard to the duties of the arbitrator. What about the tribunal making findings about an issue that was not put forward by the parties, and then not giving the parties an opportunity to address the argument that the tribunal itself has identified? Again, perhaps it would be appropriate to set aside parts of the award rather than remit the award back to the tribunal, and then whether it would be appropriate to remit that part to the tribunal due to the nature of serious irregularity and extent of the impact on the dispositive relief. And final example, the tribunal concluding that parties had a particular common assumptions on an issue, then again, failing to give parties an opportunity to cross-examine witnesses, which would reveal that the parties did not have that common assumption. And so the assumption by the tribunal is wrong. So failure to order cross-examination in that context can be considered a serious irregularity. I mean, I appreciate that the English court has had the opportunity to look at far many more cases, but it is that case law, even if the result is that the awards stand, that provides tremendous comfort to the users because they're able to see how the judges think and where the argument falls, because often it's a very fine line. On the same application, describing the conduct of the tribunal may have slightly different factual scenarios and the result would be different. And it's perhaps that experience that makes the users comfortable. Now, on a more granular level, users expect the court to provide appropriate assistance also with appointment of arbitrators if it's not an institution and their challenge. On appointment, I will say only one thing. What we see now in the context of the sanctions and Russian parties is a lot of the Western institutions such as LCIA, ICC, Stockholm are very alert to the fact that they have to look at not only the requirements and everything that they used to look at, but also the perception of bias. And what I see when I have the institution appointing arbitrators in the context involving Russian parties, they will never appoint, at least not that I have seen, perhaps they do occasionally, but they do not appoint nationals of a state that has introduced sanctions against Russia. And it's not written anywhere. It's not in any rules, but that's certainly a very important perception that, again, if the courts are exercising that function, is important. On challenge, again, it's very good to see the court's approach to challenge for bias on the basis of undisclosed multiple appointments by the same parties in related cases. There's quite a lot of English law on that issue. And when the test, so the fair-minded arbitrator or fair-minded observer, informed observer is applied. So do you look at that issue at the time of the court proceeding challenging the appointment, or at the earlier time of the arbitrator's failure to make disclosure? Again, this is something that the court, faced with that issue, will have to consider. And finally, on the challenge is the extent to which the court considers or relies, probably doesn't, but the IBA guidelines. The English court, for example, considers it helpful, but it does not override national law or arbitration rules. And there have been cases in the English court where even failure to disclose a circumstance which is on the non-waivable red list of the IBA rules, never mind, was not found to be fatal by the English court. And finally, the topic of interim relief and assistance in taking evidence. Again, this is important for the users to have the opportunity to see how the court considers these issues. In choosing the seat, this is probably one of the most important considerations. And having heard today that there are applications that are successful in obtaining freezing orders in support of arbitration, certainly that's going to be an important feature and something that the parties definitely want to avail themselves to. The extent of orders against known parties, again, the order for taking evidence of a non-party witness, I heard that that's not something that the esteemed judges had experience in, unless I've missed something, but it will come at some point, because again, the tribunal will only have power over parties to the arbitration agreement, and it's and that's fine. There are ways of dealing with that. Perhaps that's where you don't really require that much of a court assistance, but it's the non-parties which make the arbitration in conjunction with the judicial assistance most attractive and most useful, and that's where the proof is in the pudding. And finally, the anti-suit injunctions. The anti-suit, whether the UAE court will issue anti-suit injunctions to restrain court proceedings in breach of arbitration agreement, including a mandatory injunction requiring a party to take active steps to terminate court proceedings already commenced. I mean, that's taking it slightly further and giving it some teeth. There is an important consideration for parties from Russia or parties dealing with Russian parties when it comes to anti-suit injunctions. As you may all know, that there are plenty of cases now where there is an arbitration agreement, typically a Russian party and a foreign party, and the Russian party brings proceedings in the Russian court in breach of the arbitration agreement, and then obtains in Russia an injunction which prohibits the parties from complying with the arbitration agreement or commencing arbitration proceedings. And often that's accompanied by the foreign party being ordered to pay a financial penalty, which is equal to the claim that it makes in the arbitration, if it breaches the Russian court order and goes ahead with the complying with the arbitration proceedings. So just those of you who are not familiar with why that is happening, such legal action is based on provision of fairly recent Russian domestic law, which was enacted in response to Western sanctions against Russian entities, which purports to give the jurisdiction to the Russian courts to issue such an injunction on the basis that the arbitration agreement that the parties have concluded is unenforceable. And that's because the place of arbitration is in, and that's a term, an unfriendly country. An unfriendly country is a country that issued sanctions against the Russian Federation. As I mentioned it at the beginning, the UAE does not fall into the category of unfriendly jurisdictions in the eyes of the Russian court. However, those of you who have been following this issue perhaps have been surprised to read one of the recent Russian court decisions looking at Hong Kong, which is also shouldn't be falling into an unfriendly jurisdiction. But there, in their desire to step away from the arbitration agreement, the Russian court said, oh, well, you know, in Hong Kong, you've got too many English judges, therefore they're all agents of the enemy. And therefore, it's as unfriendly as it would have been had it introduced sanctions. I mean, that's an extreme view, but a view that shouldn't be dismissed. So I think that's all I had to say. And I think my main message is that this jurisdiction has a lot of potential, but it would be very useful to have a discussion about how the judges would consider specific issues, whether it be by discussing hypothetical applications or whether in the absence of real ones. because nobody wants to be the guinea pig and be the one whose case is considered in an unexpected fashion when it comes to judicial support to arbitration. Thank you.
Thank you, Julia. That was, again, very, very comprehensive and quite broad in terms of the issues that you raised. I think that the best way to proceed with some of those points is actually to turn them into questions directly for the judges once we're through with the initial presentations, which I think would be most useful, and they can give direct answers to those. There are 2 points that stick out to me in the main. The first is a nuanced point, which you're absolutely right to make, which is that for the courts to prove their quote unquote arbitration friendliness, it's not just a matter of them blindly or robotically following a policy that rubber stamps everything to do with arbitration. It's more about discernment, more about judicial scrutiny and attention to detail, to look at the particular issues at hand and develop arbitration experience out of that. Now, as regards enforcement, for example, I would be quite positive about the jurisdiction, both the DIFC and the Dubai courts. I think that far from just showing promise, I think this jurisdiction is actually leading the way in many respects, both according to the experience of a number of professionals, anecdotal experience, and also the statistics. There's a particular reference paper, that a study published by a Lebanese arbitration practitioner called Karen Saif 3 or 4 years ago. The article's entitled "Let the Data Speak for Itself," and it does. It's about the proportion of successful enforcements and recognitions of international arbitral awards in the Dubai local courts over a 12-year period. So the statistics for successful enforcement in the UAE courts are somewhere in the region of 60 to 65%, which is a very healthy rate. In the DIFC courts, obviously, they have the expertise, not just of Justice Shamlan leading the division, but others. And so I would say, far from just showing promise, the jurisdiction is actually, in many respects, setting the trend for the region and also internationally. The other point of interest was, I mean, there were so many to pick up on, but the point about neutrality, and even in how that could extend potentially to international free zone courts or international commercial courts such as the DIFC or the Hong Kong example that you gave. I mean, this is really fascinating. And then you're back to the one of the fundamental questions about composition there, and those forums composing themselves, nominating and appointing judges, bringing through judges that have the necessary hybrid backgrounds to deal with the kind of cases that are before them, but also to put parties at ease that there isn't a very particular one-sided political or policy position put forward by the institution. So much to deal with there and so much to think about. And as I said, the questions are probably best put to the judges while we have them on this very special occasion. But I'd like to move to Mohammed now. I'm conscious you've been waiting for some time. You've heard everything that you have. So again, I would say feel free to give any comments. But given your experience in private practice, and particularly based in Sharjah, so outside of Dubai, what's your experience of interim judicial assistance in arbitration, more broadly in seeking interim court measures to assist you in arbitral processes, and then perhaps give us a thought on enforcement, because I'm conscious that you've had some great successes all over the UAE.
Thank you, Faris, and thanks to my esteemed colleagues and the Russian Arbitration Center. You know, there is no doubt that the UAE has witnessed significant movement in terms of enhancing the the legal landscape with focus on the developing the arbitration legislations. And this was witnessed by virtue of the 2018 law, which has based on the UNICITRAL model law. And when it comes to the judicial assistance, there is no doubt that the UAE offers, the UAE courts, offers many forms of judicial assistance to the practitioners in the arbitration field, starting from even before commencing the arbitration proceedings. You may now seek interim order from the onshore court. And more importantly, you may even seek an appointment of an expert via the Amicable Center for Dispute Resolution, which is an affiliate of Dubai courts. And what proved the liberal approach which the UAE courts now has adopted most recently, that parties usually, plea that the applicant who has applied for such legal proceedings before the Amicable Settlement Center has waived the arbitration agreement. So the UAE court has just adopted the truly opposite position and held that approaching this center doesn't mean that you have waived the arbitration agreement, which is offering key assistance for parties for the sake of taking evidence and proving the status of the case in an efficient and expedited way. The same applies for the composition of the tribunal, where the court offers the assistance for appointing arbitrators in ad hoc arbitration. And even during the lifespan of the arbitration proceedings, you will witness great assistance from court. And the good point that, unlike what the major people or the majority of people perceive, that onshore courts are always delaying the process and that it takes long time for you to take an order from an onshore court, absolutely. We even deal with, with the enforcement process for international arbitral awards on expedited basis that, from my point of view, offers special treatment for international awards over the local awards. So if you have, for example, an award that is being made in London, you would be able to enforce it here, theoretically, let's say, within 3 days from the date of filing the application before the enforcement judge. But in practice, yes, it might take long time, but but long time doesn't mean month, for example. No, it's a matter of, in practice, 1-2 weeks for you to obtain an order for enforcing an international award. Likewise, for local arbitral awards, it's enforced by way of an application to the Chief Justice of the Court of Appeal. So from all of this, we can just, agree that the UAE seat becomes like one of the key seats around the globe, that now we are competing with, seats like London and Stockholm, So this is one of the things that make me proud to practice in this area. But I would like also to comment on the issue of the anti-suit injunction, that it's, we have different perception when it comes to how UAE courts deal with arbitration agreement and whether it will accept the jurisdiction despite the parties' agreement. That unfortunately, so far, the court does not have the initiative to declare that it has no jurisdiction to hear the case despite the parties' agreement. And there is no such legal mechanism for the respondent, let's say, to obtain an anti-suit injunction. I'm talking from onshore courts' perspective. And which from my point of view, I see that it's consistent with many approaches around the globe, including for sure in the Middle East and also in the West countries. But in the good point here that I have come across, for example, a case where there was legal proceedings in the UK, ongoing legal proceedings in the UK, and that was impacting the UAE court jurisdiction and the ongoing proceedings in the UAE. At the time, we successfully obtained an anti-suit injunction to enforce the respondent in the UAE, who is claimant there, to refrain or to stop from suing our client in the UK. And so this is how the court would deal with anti-suit injunction. But again, and the drawback of this position, that now you might find a case that is going for years, and the court does not decide on its jurisdiction unless it passes its final judgment. So I think this is one of the points that the UAE court is advised to just to look into it, to have like not a summary judgment, but a partial award with regards to its jurisdiction, because now I would have to wait in the court and follow the legal proceedings until it's concluded. And in many cases, the court even look into the substance of the case, appointing experts, you know, and then it goes to the Court of Appeal, the Court of Cassation, without providing its findings when it comes to its jurisdiction until the last moment. So I think this is one of the key points that requires even to amend the civil procedures law in order to have a mechanism for the court to decide on its jurisdiction at the beginning. Last thing with regards to just to comment on the whether the court would just rubber stamp the arbitral award and take it for granted that this award has satisfied all the prerequisite and it you know, and it complies with the applicable law. I disagree with this approach, because what I have seen that the court even take positive role while it looks into arbitral awards. And for example, most recently, the Dubai Cassation Court has passed a judgment just against the res judicata that being obtained by the first court order, which because the arbitral award wasn't signed, all the pages of the arbitral award wasn't signed. So this award was set aside by the Dubai courts, and thereafter the judgment creditor applied for the arbitral tribunal in order to rectify this defect and pursued new legal or fresh legal proceedings for the sake of enforcing the award. The Dubai Cassation Court held that there is no res judicata obtained from the court of from the previous court. Why? Because now the system really changed. This is and the last point in this regard, when it comes to weighing the evidence, whether the court would just ignore the fact that the tribunal has disregarded the parties' request to consider their to testify, for example, an expert witness or examine them. Even when we apply for the cassation court in the UAE and contest the Court of Appeals judgment on this ground, the Court of Cassation tend to say that this is fall within the discretionary power of the tribunal, or I mean the lower court, that the Court of Cassation has no power to assess. Likewise here, they are considering the same concept when they are dealing with such challenges in terms of the management of the legal proceedings during the life of the arbitration. So thank you.
Thank you, Mohammed. That's very helpful. I could see when you mentioned 3 days, Justice Ahmed was shaking his head. But then when you mentioned a couple of weeks, But yeah. But I mean, very good. I understand that Justice Shamlan wishes to make a few comments now. Please, Justice Shamlan.
Yeah, just of course, I totally agree with my colleagues' comments. Just general comments about, let's say, the practice before the DIFC courts. As you know, the threshold is very high to set aside an award, and it's not like a blank check given to the judgment creditor to enforce it. But of course, the respondent or let's say the applicant who want to set aside have to approve the case that there is a very good case. They have to, convince the judge to set aside the award. None of all of those example you gave, Julian, it's available. Recently now I have an application to set aside an award because the reason given by the arbitrator is not convincing and very short. I have to entertain this, still I haven't made my mind. But I want to comment as well about the anti-suit injunction. So I come across with a recent judgment from Abu Dhabi court where the tribunal, it was a DIAC tribunal, that the tribunal itself, they issue anti-suit injunction. They make an order to respondent to stay proceedings before the Abu Dhabi court. Now, of course, this order or the applicant took the order to Abu Dhabi court, and Abu Dhabi court disregarded and say, look, under the UAE arbitration law, this is not of those power giving to the tribunal to give a stay for proceedings. And they say this is against the public policy. Everyone have to come to the judiciary and make their case. So this is one of those reasoning where sometimes this type of remedy is not practical in our culture and the judicial culture in onshore courts. This is very important. I don't think I have that much of comment to say. I will leave the floor for my colleagues as well to maybe Justice Hassan want to comment if you like.
بالنسبة لملاحظات بعض الإخوان أستاذ محمد وأستاذة، أول شيء لازم نضع في بالنا أن عدم التدخل الموضوعي للمحكمة في حكم التحكيم هو احترام لإرادة الأطراف ذات نفسهم. في حالة اتفاقك على التحكيم أنت تختار قاضيك اختيارا، وبالتالي تتحمل أخطاء هذا القاضي باعتبار أن هنالك ضمانات كافية في القضاء العادي أن يصدر الحكم من أول درجة ويتم استئنافه في وسط محكمة الاستئناف لقاضي أكثر خبرة، ثم يتم الطعن فيه أمام محكمة التمييز أو المحكمة العليا، وهنالك يكون هنالك قاضي أخذ تجربة وسن طويلة في الخدمة. يعني هنالك رغبة على القضاء العادي من خلال درجات التقاضي وهي ضمانة كافية. فإذا أراد الأطراف النزول عن هذه الضمانات ولجأ إلى التحكيم فعليه أن يتحمل أخطاء التحكيم في مسألة التقدير الموضوعي أو في أدلة الدعوة، وأن القضاء لا يتحمل إلا أن يحترم هذا الاختيار. وبالتالي أقف بعيدا في مسألة التقدير الموضوعي، وكل أنا بفتكر كل القوانين أو غالب القوانين اللي اطلعنا عليها في إنه الرقابة في حدود ضيقة في مسألة الرقابة على حكم التحكيم من خلال المحكمة. ومسألة ما أثاره الزميل في مسألة أن هنالك يعني في حكومة التمييز غضب إنه إعادة الأوراق أو إعادة حكم التحكيم للتوقيع من الأعضاء، أنا أتفق تماما. أو أصلا النص موجود بالقانون، قانون أعطى الحق المحكمة، ومن بعد هو إجراء شكلي. مسألة إجراء شكلي بتفادى بها بطلان باعتبار انه التحكيم ذات نفسه اخذ زمن مصروفات التحكيم، فما يمكن ان يبطل الحكم ويبطل ويضيع كل هذا المجهود وهذه المصاريف الصرفت من اجل اجراء شكلي يتضمن على هو توقيع المحكم او على الصفحات التي لا يتم التوقيع عليها. وبالتالي إذا كان يمكن أن تدارك هذا الإجراء الشكلي فلماذا لا نمنح الهيئة التحكيم، ولماذا يكون هذا سبب بطلان مع أنه التحكيم يمكن يكون قضى مدة طويلة وتم صرف ودفع رسوم المؤسسة التحكيمية ورسوم الأعضاء وهيئات التحكيم بإجراء شكلي بسيط. ليس من الحقيقة، ليس من
حسن بيه بس يعني I want to comment about the signature of the award. Okay, the case that my colleague is talking about is that the award not been signed. It's not been signed. The signature will be on a separate paper, on a separate paper, not on the original copy of the award. So I have no chance to say this is this kind of an award related to this arbitrator. Okay, there is no relation. You know, and if we give you this award, it's not been signed. Okay, who issued this kind of an award? The case that you're talking about is that this is it gets from the separate paper. I never ask the question of law about whether the award is right or not or wrong when you're telling me that a tiny little process of the awards not being followed. This is not the way I answer the question of law whether this the award capable of enforcement or not. This is the small comment about my colleague is talking. Thank you.
Well, actually, I wanted to also say that, first of all, something that I find extremely helpful and something that, for example, I haven't seen in Russia very much is the interaction of this type, because, and I think as we were preparing for the panel, I said it's extremely important for the judges to be able to speak to practitioners and to also hear what the expectations of the practitioner's clients are. All the questions that I gave in my presentations, they were issues that the English court came across, apart from one, which was from the Russian court, but most of them are English court. And it's great that in this jurisdiction, you are far more advanced because you've seen how in other jurisdictions, the courts have looked at it, what the expectations are. I think in the context of setting aside the award, there is a very fine line between, for example, a party arguing that the award is not reasoned enough or illogical or short or whatever, and then a suggestion that certain conduct of the arbitrator or the tribunal went to the core issue, because the tribunal has quite a wide discretion on how to, and this goes back to absolutely everybody who's been saying, it's the will of the parties, including you choose your private tribunal, you trust them, you entrust your case into them, so the court should not interfere. But then you have the court is the gate, the final gate, which gives comfort to the parties that if the chosen tribunal didn't conduct itself appropriately, then you have the judiciary who will put it right. And so, for example, the question where, and that one actually arises quite often, the tribunal of its own accord identifies an issue, no party has made any submissions on it, and runs away with it. And then doesn't really allow the parties to flesh out that issue, because sometimes the tribunal likes its own thinking so much that it's already convinced that that is the central issue in the dispute. What would and the party says that, look, the tribunal got it wrong. No party made submissions on this issue. Then we were not allowed, when the tribunal identified it, we were not allowed to put forward any arguments, or we were not allowed to cross-examine witnesses, which we say would have revealed that the assumption is wrong. What would be the approach? And I mean, there's no right or wrong answer. What would be the approach of the judge?
I may comment. I mean, under the DIFC arbitration law, there's one of those grounds to set aside, of course. If the tribunal resolve an issue was not part of the issue of disputes, or the party wasn't given opportunity to defend themselves or to make a proper submission. Of course, this is already written. I haven't seen those yet in my court. I'm not sure about the Dubai court, if they have an experience, or Ras Al Khaimah court, or maybe in Sharjah court. That would be great if we can hear from other court as well. Justice Hassan. لا بس انتم محاكم دبي، هل مر عليكم انكم قضيتوا ابطال حكم تحكيم لان المحكم خارج موضوع التحكيم، او انه الاطراف لم يتمكنوا من الدفاع؟
والله هي لا ما استند عليه في البطلان حالات محددة بالقانون. في حالة عدم المواجهة بين الخصوم أمام هيئة التحكيم، أو الإخلال بأسس التقاضي في منح الأطراف في تقديم ما لديه من مستندات وتقديم ما لديهم أوجه دفاع. دي حالة من حالات البطلان، وحقيقة من 2018 تكاد إنه دي الحالة دي منعدمة تماما. يعني قد يسير المحتكم أو يسير المدعي في دعوى البطلان، وعندما أطلع على حكم التحكيم وأجد أن هنالك أن هيئة التحكيم منحت المدعي حق تقديم مستنداته وتقديم مذكراته واحتراضاته، لا حقيقة لا أقف كثير في مسألة كون الهيئة التحكيم أخذت بهذا المستند والتفتت عن هذا المستند وأخذت بأقوال الشاهد والتفتت عن هذا الأقوال وندبت خبير، ولم تأخذ في مسألة تقدير الخبير ما تراه كافي أو مناسبا بالنسبة لي أنا كقاضي في مسألة التقدير، باعتبار أنه أنا ملزم باتباع القانون، والقانون حدد الحالات وبالتالي لا يمكن أن أتجاهلها وأدخل في العمل الموضوعي لعمل المحكم، باعتبار أنه المحكم ده قاضي وهو قام بما عليه من حق. وبدليل حتى القانون أدى الأطراف حق أنه حق أن يمنحوا هيئة التحكيم إصدار حكم بدون تسبيب. قانون نص في حالة أنه يمكن الاتفاق على أن تصدر هيئة التحكيم حكما دون تسبيب، وهذه بفتكر أنه قاعدة كافية في أن الأطراف هم الذين يشكلون لهيئة التحكيم كيفية إصدار الأحكام. وبس هنالك أرى أنه هل المؤسسات التحكيمية تقوم بدورها في مسألة اختيار المحكمين، في أن يتم ضمن أن يكون هذا محكم وهذا غير محكم، أي كان. إذا كان هنالك نزاعات تحتاج لخبرة في مجال النزاع القانوني، في المجال النزاع التحكيمي أقصد، إلا أنني أرى أنه لا بد للمحكم أن يكون ملما بالقانون، لا بد أن يكون المحكم يلما بالقانون، فلا يكفي أن يكون هو مهندس في مجال الطيران أو مجال البحرية أو مجال الطاقة ليقضي في نزاع، لأنه لازم المحكم محتاج لتقدير البينة، محتاج لتقدير الدليل، محتاج لمعرفة النص القانوني الذي يحكم النزاع، وبالتالي لا بد أن يكون المحكم ملما بالقانون. وهذه مسؤولية المؤسسات التحكيمية. أما في حالة المحكم الحر، إذا كان طلب التعيين للمحكم من المحكمة من جدول الخبراء بالمحكمة، فالمحكمة بتعين الخبير صاحب الاختصاص في النزاع التحكيمي، فضلا عن أن المحكمة في قبول الخبراء كمحكمين هنالك إجراءات تتبع لتعيين الخبراء أو كقبول كمحكمين، بدليل أنه حتى هذه اللحظة لم يتم إدراج جدول بخبراء محكمين مع محاكم دبي، باعتبار أن هنالك إجراءات ألزم القانون اتباعها في مسألة تعيين المحكمين. فأنا أعود وأقول اختيار الأطراف هو الواجب الاحترام، وبالتالي ينحسر دور الرقابة الموضوعية كما صارت كل القوانين أو كل أحكام ما اطلعت عليه بأحكام محكمة التمييز والمحكمة العليا ومحاكم تمييز رأس الخيمة، وأنا ملزم باتباع هذه القواعد والأحكام.
Shukran, Ustaz. I think we now have maybe 10 or 15 minutes to take questions from the audience. I'm conscious that we have a high proportion of very esteemed arbitration practitioners, both counsel and arbitrators, in the room with us. So perhaps we'll pass the microphone around if the microphone's in front of each of you. I understand they do work if you just press the button. So please, any questions? Yeah, one at the, we'll take the first one from the gentleman on the left, and then the lady on the right, and then Joseph Shadrawi. Yeah. I think if you press the, yeah.
Hello. Yeah. Yes. Thank you very much. It's an amazing panel here. And
Can you
so-
just introduce yourself?
Right,
Sorry,
okay.
before we.
So, sorry, my name is Samir Khan. I have my own law practice over here, SK Legal Consultants. I've been here since 2010, practicing in UAE. So, in my experience, I've seen huge progress in arbitration cases from Dubai courts when I first came in 2010, and now this is, Dubai courts are extremely pro arbitration, if anything else. My question is because the judges are over here, so I want to take this opportunity just to point out one concern that I have, and if that's something that could be allayed. It is regarding judicial assistance with respect to arbitrations, and I'm going to give a very specific example here. Basically, we have tried to apply, and in the past we do regularly apply for attachments of guarantees when there are, let's say, construction disputes, and we are on behalf of a contractor going against, or a subcontractor going against their contractor, or a contractor going against a client. And in that role, what we find is that whenever we apply, if our application, and it's an interim application for attachment or freezing of guarantees, just before we go ahead and initiate a arbitration, if our application gets rejected, then you don't get reasoning. You get a simple rejected answer. Now, that is, we find it quite unhelpful because it does not make us practitioners more intelligent in terms of our practice over time, because we cannot then advise our clients, okay, why did we get this wrong, and how we can improve later on. And this is a concern that, judges are requested that probably introduce reasoning even when they reject it, and explain to us why they're not accepting this application. So next time we get it right in those of what documents we should have had or what approach we should have taken. Thank you.
It's a brilliant question, Samir. Over first to Saad al-Ustaz, Judge Ahmed, I think, has been given the responsibility.
It's not a matter of right or wrong. It's not a matter of right. If you get rejected, that does not mean that you are a bad lawyer. No, not at all. It's about the proper. I, as a judge, consider that this kind of action is not proper at this time. Okay, so you have the right to make this kind of an appeal in front of the court of appeal. You can argue whatever you want and make the documents that you need to deliver. What I'm trying to explain that when you ask the judge for just an order which is related to the arbitration process, I'm very conservative. I cannot just say I give it this order or not, answer it or deny it. So it's not a matter of right or wrong. It's about the was it proper or not, and at the time that you ask for the order. Thank you.
Sorry, just a clarification. My question was on the reasoning, if that could be provided when you do when you reject the decision.
The law did not oblige me to reason this kind of an order, but I consider it, according to the circumstances of this kind of the case, it's not your right to give you this order. I was not proper. I would maybe it could affect the arbitration in a way or another, or the award in a way or another.
Can I just maybe buttress that question or put it in a different way? So I know that you said that you're conservative in the way that you approach that. Is that a matter of personal judicial style, or is that a policy position on behalf of the court?
Because as I try to explain, when I try to interfere, I mean not Ahmed as a judiciary. When I'm trying to interfere the process of arbitration, I don't put my will or the law will against your will as a party. I just give you a hand in some kind of points that you need me to do it. So by law, I cannot give reason for this kind of order. Okay, maybe the court of appeal, if you appeal this kind of order, you will get the reason that you can explain what you want. But by law, this is not my role.
I just wanted to add one point, that in all events you would have the right to file a grievance to the same judge, where he will provide his reasoning why he has rejected or dismissed your application, and this would come as a first before filing the appeal to the higher court.
I think Samir would probably say to that, then that's just additional time and expense, and I have to go through all the tiers to get the reasoning I'm looking for. But I understand the point. تفضل سعد.
بالنسبة له هو ده اتباع إجراء القانوني. الأوامر المستعجلة تصدر بأوامر على عريضة، والأمر على عريضة لا يسبب. بعد أنت بتحتفظ بهذا الحق في التظلم في مسألة الرفض أو القبول. عندك الحق إذا رفضت بتعمل تظلم، وده تنظيم القانون. دي هنا ما سلطة تقديرية للقاضي، سلطة تقدير ما سلطة يتحكم فيها، إنما هو ملزم بالقانون في الأوامر على العريضة. يتم الرفض دون تسبيب، وللطرف المتضرر الحق في التقدم بالتظلم يشرح فيه القاضي لماذا رفض طلب الأمر على العريضة بعدم اتخاذ الإجراء الوقتي. ومن ثم يكون إذا تم أو صممت المحكمة أو القاضي الذي قام بالتأشير على القرار على الطلب بالرفض على قراره، لا بد عليه أو يجب عليه أن يسبب الرفض ويكون هذا قابلا للاستئناف. فالإجراءات محفوظة والقنوات محفوظة بحكم القانون، ما إن شاء الله.
Judge Shamlan, just quickly, because I want to try and take as many questions as possible, but I heard you wanted to express a view on this. Slide it to the right.
I just want to say it depends where you're going to choose the seat of your arbitration. If you want to this type of remedy, you want the full reasoning before you move on, then you have to go to the a specific court like a DIFC court or common law, we give that kind of practice. If you are international lawyer, some of local lawyer, they are familiar with the local practice and they're happy with this type of formatting, which is not mandatory for the judge to give reasoning unless it's a second time. This is the only form of choice.
Yeah, okay, so the next question was from the lady in the white, I believe, or Joseph Shadrawi, yeah.
Samra has very kindly allowed me to go first because my question actually follows on from the last question. So my name is Joseph Shadrawi. I'm a partner at Covington and Burling. In addition to my counsel work, I sit as arbitrator. And on both sides, as counsel and as arbitrator, I'm seeing more and more provisional measures being sought from the local courts. But it doesn't seem that many of them are very successful. And so a question for the judges is, what do you think parties who are seeking provisional measures could do better to achieve success in obtaining provisional measures?
Just to clarify, that's in the local courts.
Local courts.
Yeah.
Actually, I have no idea. Don't know, but it seems to be that there is something wrong in your approach, but I don't know why. Maybe it's the maybe it's about the culture. The culture is very important to changing the mindset in order to change things for a better way. So I believe this is related to the cultures, and I have no further comments.
This remedy does not exist. I mean, in the onshore courts. ساعتك will the if it exists or not, why it's not practiced? I don't know.
But I just wanted to add to this that we as practitioners at onshore courts, we are facing the same dilemma. So it is not an issue with the arbitration only. So because my consideration that judges are thinking always that the initial position that this application should be rejected. Why? Because you are going against the basic fundamental rights for being heard. So you have to prove the contrary, to prove that you have a solid case on the face of it, which doesn't exist in the majority of cases, which requires further clarification or examination of the documents.
Just to tally your experience with that of Joseph. So Joseph mentioned that in his experience, both as a practitioner and sitting as arbitrator, from the international perspective, that he's seen a low level of success in interim measures from the local courts. What's your general experience as a practitioner who mostly appears before the local courts and is filing travel ban requests, attachment applications, and so on a regular basis? I mean, you've done hundreds of these. And so, I mean, how would you characterize that experience in terms of prospects?
In terms of prospects, they are not high, because unless we have conclusive evidence that is proving the claimed debt, I'm talking about a specific remedy that you are seeking in these legal proceedings, like, for example, post-dated checks or bank guarantees or acknowledgement. It's highly unlikely for you to obtain a favorable order in the context of summary legal proceedings.
Thank you. Do we have any other questions? We've got one from Shafi here at the front, and then we'll go to the back. Oh, sorry, there was the lady in the white. Sorry, please.
outside the region, enforced in the region through the DIFC. So in that sense, are there examples of the DIFC courts taking jurisdiction to enforce a non-GCC, non-Riyadh award, first in the DIFC, and then taking the DIFC enforcement order as a judgment of the DIFC court, and that being enforced further under the Riyadh Convention or the GCC Convention in the region as a judgment of the DIFC court?
So, very short, I mean, if you bring in any international award to DIFC, it will be enforced under New York Convention. This is to start with. And for recognition and enforcement application, as I said, there is no need for assets or the party to be within the DIFC. It's the arbitration law, and it's very open in that regard, Article 42. And I believe this is maybe the same approach the Singaporean judiciary they take to make the award is ready to be enforced in the future, DIFC, I think. When it comes to the DIFC judgment, again, it will be seen as a judgment came out of UAE, and then it will be 100% enforced. And we've seen some evidence, our judgment being enforced in Dubai or in Abu Dhabi or in Saudi Arabia or Bahrain or Kuwait under the GCC enforcement. And there's an enforcement publication, enforcement guide published on the DIFC court website. I will invite you to have a look to it. Yes, thank you.
I think I'll take one at the front and then the one at the back immediately after, yeah.
Thank you, Faris. My name is Shafiq Jamous. I'm the Chief Legal Counsel of a business group in Dubai, and I also sit as an arbitrator. First, thank you for the distinguished panel for the enlightening contributions. My question today is as a user of arbitration, as a party to arbitration. One of the concerns that as a party I always have when I choose arbitration is that there is simply no way to fix a procedure in arbitration. When an award is taken to court, it's either recognize, enforce that award, or simply reject it. There is no way to fix it, unlike the approach of local courts taking basically the possibility for the Court of Appeal to fix or rectify or guide lower courts to reconsider and correct their judgments. So my question is, and my question is to the honorable justices here, isn't there a middle way? Today, in the arbitration law, we see the grounds for the rejection to recognize an award or enforce an award. One of them is, for example, the lack of opportunity to present one's case. Another one is a procedural irregularity, but that can be really anything. So, as a party to arbitration, I submit a request, for example, for the production of documents. The arbitrator does not allow me that opportunity or limits that exercise to a significant extent that I'm not really able to get the evidence to support my case. Or I am deprived of the opportunity to present witnesses or to cross-examine a witness. I'm not saying this is common. Again, fortunately, we deal normally with senior and well-experienced arbitrators. But let's say that scenario happens. My concern is when there is an award and when I have one right that was not respected by the arbitrator, my award goes to court, it will likely be simply rejected. So what is it? So my question, it's two parts. Is there a middle way? Is there an option to redirect the tribunal to rectify an award? And that will be followed by the second part, which is the current legal framework restraining you, restricting your powers to take that middle way that maybe some further legal reforms are required for the arbitration law? Thank you, sir.
I can give very, very quick comment on you. Just, I mean, don't come late. This is the point. You have to make your case very early. I mean, what about you are not happy with the outcome of jurisdiction in terms of with the tribunal in terms of jurisdiction, you know, order that they have jurisdiction or they don't have, or any of those circumstances, you're not being given the opportunity to protect to protect any documents. Come to the seat of the court, the supervisory court, and make your application. Don't wait until the award being issued and come and argue later on. Now, this is the job for the counsel who's leading the claimant or the respondent. If they didn't identify those issue earlier, then because by the end of the day, we need to balance with both sides. I mean, if the court was involved earlier and been asked to help with this type of argument, this is what the court can do for you earlier stage. So if you leave it later on and come and make it as a reason to set aside, that will be really, a struggling position, if I may say. Please go ahead, Mr. Ahmed.
Completing my colleague, there is no way, my dear. If there is a way to fix this kind of a thing, I was more welcome to do it for you. But this is your choice. So choose the right arbitrator, choose the right, made your homework with the agreement that can make it right for both of you. And don't you ever let something that bother you pass, and then I will say, okay, I will make the objection at the end. No way. In the middle, at the time, because this makes a difference. I usually experience this. If you make the objection at the right time, maybe I can help you at the end. I am Ahmed as a judiciary, and okay. So do your homework, and God be with you.
This is just a point at which I'd like to bring in Valeria, because the question that Shafiq asked is very important, because I mean he's essentially framing the issue that was raised by Julia earlier, saying that what sanctity is available in the event of wrongdoing. What can the courts do? Now, I'm conscious that the Russian Arbitration Center, obviously to the extent that it's administering the proceedings, will have a form of scrutiny or soft scrutiny, according to the way that most institutions have. And so I would rephrase his question to you and say, are you at the RAC generally watching what's going on? Obviously needing a request from the parties to the tribunal to show discontent, but are you watching what's going on in the lifespan of the proceedings and then capable of making a comment before the award is rendered?
Yeah, sure. I think it's what we do on daily basis, and we do it not only if we have the request by the party. So we really try to figure out if there are any potential comments, any potential things that would be that would affect the enforceability of the award. And also, I would like to comment just a bit regarding the enforceability of like the interim measures, the question that was raised before. We have the same problem in Russia. So the provisional measures usually are not so popular among the state courts. And I think we really have the attitude of the UAE courts and the Russian courts is quite the same. And I would say that sometimes you really need to look into the arbitration rules. Maybe they provide for some opportunities to make these provisional measures enforceable. For instance, like in Russian Arbitration Center, we have the provision that allows the arbitral tribunal to issue like a fine if one of the parties does not comply with provisional measures rendered by the arbitral tribunal. And this fine could be enforced by the court. So it is kind of a way to not to go directly to the court for provisional measures, but to get the enforcement through the order of the arbitral tribunal. So,
thank you, Valeria. I'm conscious that I've kept a lot of people waiting for a long time. The gentleman at the back. Yeah.
Is it on? Thank you very much. My name is Dimitri Mednikov. I work at Galdari Advocate. First of all, thank you very much for the organizers and for bringing such an illustrious panel together. It's I echo Yulia's comment that it's invaluable to hear judiciary's perspective on the enforcement of arbitral awards. I have two questions, if I may. The first one to Justice Hassan and also Justice Shamlan. It's about enforcement. Let me put it that way. Would DIFC courts and Dubai courts enforce a foreign court judgment that was issued in breach of a valid arbitration agreement, but where the court that issued that judgment had jurisdiction based on its national law? So this is the case with the Russian Civil Procedure Code. The second question, and we'll go to Justice Hassan only, well, unless other speakers want to chime in. I appreciate what's been said about Dubai courts rarely setting aside arbitral awards these days, and it's a very positive trend. But I think there is a very concerning, a pair of very concerning decisions from the one from the Dubai Court of Cassation and the other one from the Dubai Court of Appeal. The first one was this year, the Court of Appeal was last year, which in part set aside an ICC arbitral award, having found that under ICC rules, the tribunal does not have authority to award legal costs. And if you could just maybe comment on that development. Thank you.
Well, I mean, if I understood your question, whether the DIFC court would enforce a foreign judgment, if that foreign judgment was against the public policy or a mistake? Yeah. 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 Well, yes, I mean, but well, depends. I cannot, of course, comment on without any full circumstances, but of course, this judgment will be seen coming from non-common court jurisdiction. This judgment, we have to have a treaty with the Russian to enforce. I don't think we have it. So it will be a very difficult equation, but then it will be a matter of evidence and public policy of the IFC court. Of course, we don't have similar situation to give exact answer, but I don't know if you want to still comment on the same question by other court, or we'll move to a second question to Dubai court.
Well, yeah, I'd like to hear Judge Hassan's response to the question about the ICC enforcement, the issue of legal costs, yeah, which I think continues to be an issue, partially because of a lack of available judgments. I mean, that's one thing that we suffer from in the UAE. There are publications of arbitration-related judgments in the local court, but they're not systematized and certainly not officially translated in a way that would enable an international audience to have access to them. But over to Judge Hassan on the issue of the ICC award and costs, enforcement of costs awards.
بالنسبة للسؤال الأول في مسألة تنفيذ الحكم التحكيم الأجنبي، ويخضع لقانون الإجراءات المدنية ومحاكم. لا يوجد أي اعتراض على تنفيذ الحكم التحكيم الأجنبي، باعتبار أنه القواعد الموجودة في قانون الإجراءات المدنية حددت الصور التي يتم بها تنفيذ الأحكام الأجنبية بجانب اتفاقية نيويورك في شأن الأحكام، في شأن تنفيذ أحكام التحكيم الأجنبية. ومن خلال اطلاعي لم أجد هنالك اعتراض، ما عدا في بعض المسائل في الأحكام التحكيم الأجنبية إذا كانت مخالفة في النظام العام. أذكر إنه كان في دعوة في الشركات السينمائية في بعض الأفلام ترويجها في داخل دبي، واترفض. يعني كان النزاع حول 14 فيلم سينمائي، وتم استبعاد يعني عدم تنفيذ الحكم جزئيا بمسألة أنه هنالك في الأحكام دي يعني الفيلمين يتضمن ما يخالف النظام العام داخل الدولة، وتم تنفيذ الحكم بإلزام الشركة العربية اللي هي شركة توزيع للأفلام داخل المنطقة الشرق الأوسط ومن ضمنها دبي أو الإمارات العربية، وتم التنفيذ بإلزام الشركة الموزعة بأن تؤدي إلى الشركة المحتكمة وطالبة التنفيذ قيمة المبلغ المحكوم به باستثناء قيمة الفيلمين ديل فقط. ده من ناحية التنفيذ ما عندنا مشكلة. في مسألة النفقات القانونية بحكم القانون الإماراتي يلزم أن يكون هنالك اتفاق بين الأطراف على منح هيئة التحكيم سلطة الفصل في النفقات القانونية. وفي حالة أن يكون التحكيم المؤسسي نحن نتبع قواعد المؤسسة التي يتم تحت لوائها نظر إجراءات التحكيم. فإذا وجدنا أن المؤسسة تمنح الهيئة حق الفصل في النفقات القانونية فلا أتدخل في ذلك باعتبار أن الأطراف رضوا الخضوع للإجراءات اللي أقصد للقواعد المؤسسة. بالتالي يصير جزء الحكم في شأن الاتفاق على التحقيق بشأن النفقات المالية ليس محل اعتراض. كما قال الزميل هنالك أو الأستاذنا هنالك تعارض في بعض الحكمين، ومسألة التعارض في الأحكام مسألة واردة بدليل أن القانون أجاز للمحاكم العليا ومحكمة التمييز الانعقاد في هيئة لإزالة التعارض في الأحكام. تنعقد محكمة التمييز بهيئة لإزالة التعارض وترسي مبدأ محدد. إلا أنني أرى أنه في حالة قد يكون فادعة لمحكمة الاستئناف أنه القواعد الواجبة التطبيق ولجأت لتطبيق القانون الإماراتي بدون أن تلجأ لتطبيق الإجراءات المؤسسة التي تم الإجراءات تحكيم تحت قواعدها. هنالك اتفاق تام أو هنالك قناعة تامة في دائرة التحكيم محكمة دبي الاستئناف المحكمة المختصة، وأنا يعني أترأسها من 2018. قد يكون هنالك لبس في القانون الواجب التطبيق، هل هو قواعد المؤسسة أو هو القانون الإماراتي. هنا نحتاج لمنح السلطة للهيئة بالاتفاق، وحتى الاتفاق ما يتم بواسطة المحامين فقط، وإنما يتم النص عليه في توكيل المحامي أن يمنح المحامي سلطة الاتفاق على النفقات القانونية. مسألة إنك حتى في المشارطة يكون الطلب ده أو يكون الفصل في المسألة دي إذا تم باتفاق الأطراف في إعداد المشارطة، أقصد باتفاق المحامين في إعداد المشارطة، فمحكمة التمييز اعتبرت أن هذا ليس منحا للمحامي السلطة في الاتفاق على التحقيق في الاتفاق على الأدعاب نيابة عن الطرف المحتكم. وأترك الزميل الأستاذ أحمد يكمل.
Do we have any further questions? I think we've got perhaps time for one more if somebody has a question, but otherwise, I'd just like to take this opportunity to thank each and every one of the panelists, and of course, particularly the judges who took time out of their busy judicial schedules to be with us. Thank you very much for your time. We were grateful for your statesmanship and candor. And for sharing your very valuable experience with us, and also thank you again to Valeria and the Russian Arbitration Center, and to you all for being such willing participants. Thank you very much.